আপনারা দেখছেন ক্রিমিনাল জাস্টিস।
সকলকে আবারও আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজম অ্যান্ড কো সলিসিটর্স, এবং আমার সাথে আছেন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার, আমার কলিগ ব্যারিস্টার লিন টাউনলি। আগের সেগমেন্টে আমি গ্রুমিং এর উপর বলছিলাম, চাইল্ড গ্রুমিং। রিপোর্ট অনলাইন অ্যাবিউজ টু সিইওপি। সিইওপিটা হলো যেটা হলো চাইল্ড এক্সপ্লয়টেশন অ্যান্ড অনলাইন প্রোটেকশন। এটা হলো একটা গভর্নমেন্ট এজেন্সি, ন্যাশনাল ক্রাইম এজেন্সি কমান্ড। যদি কোনো চাইল্ড অ্যাবিউজ মানে এক্সপ্লয়টেশনের কোনো ইনসিডেন্ট থাকে, দে আর দ্য পিপল should be reported to, তাদেরকে রিপোর্ট করাটা উচিত। CEOP helps keep children safe from online grooming and sexual exploitation. তারা হেল্প করে বাচ্চাদেরকে গ্রুমিং থেকে এবং সেক্সুয়াল এক্সপ্লয়টেশন থেকে মানে সেফ রাখার জন্য। If someone is acted inappropriately to a child or young person, report to CEOP. যদি if you know that someone has acted inappropriately, বাচ্চার সাথে এগুলো করতেছে, that one can report to the CEOP. How common is grooming? কত কমন, কত হচ্ছে, কিভাবে কিরকম হচ্ছে গ্রুমিংটা? We don't know how common grooming is because often children don't tell anyone what is happening to them. যে আমরা গ্রুমিংটা কত হচ্ছে, কি আকারে হচ্ছে সেটা বলাটা বড় মুশকিল, কিন্তু অনেক সময় বাচ্চারা কিন্তু এগুলা বলে না কাউকে। Children may not speak out because they are ashamed. কারণটা হচ্ছে তারা লজ্জা পায় অথবা ফিলিং গিলটি ফিল করে অনেক সময়, and unaware that they have been abused. যে তারা বুঝতে পারে না যে তারা তাদেরকে অ্যাবিউজ করা হচ্ছে, এই জিনিসগুলো তারা বুঝে না। Believe they are in a relationship with a boyfriend or girlfriend. তারা মনে করে কি সে তো আমাকে খুব মানে সুন্দর সুন্দর কথাবার্তা বলতেছে, আমরা একটা বয়ফ্রেন্ড গার্লফ্রেন্ড রিলেশনশিপের মধ্যে আছি। এগুলা অনেক সময় এই কারণে তারা এগুলা এক্সপোজ করে না, কেউকে ইনফর্ম করে না। গ্রুমিং ইজ সিরিয়াস অফেন্স অ্যান্ড ট্রায়াল ইজ লাইকলি টু বি ইন দ্য ক্রাউন কোর্ট, অ্যান্ড ইফ ফাউন্ড গিলটি, ইফ কনভিক্টেড, likely to receive the custodial sentence. Majority of sexually abused children were abused by someone they know. অনেকগুলা একটা রিপোর্টের মতো যেটা আসছে অ্যাকর্ডিং টু দ্য রিপোর্ট, যে মেজরিটি অফ সেক্সুয়ালি অ্যাবিউজড চিলড্রেন ওয়ার অ্যাবিউজড বাই সামওয়ান দে নো। তার মানে অনেক সময় এগুলো ফ্যামিলি মেম্বার এবং বন্ধু, ফ্যামিলি ফ্রেন্ডরা এই বাচ্চাদেরকে অ্যাবিউজটা করে। এগুলো হলো একটা মানে বিভিন্ন রিপোর্ট থেকে এই ইনফরমেশনগুলো আসছে। অনেকের ফেস করে সেক্সুয়াল অ্যাসল্টের চার্জ। এটা কি? রেপ হলো মোর সিরিয়াস ফর্ম অফ সেক্সুয়াল অফেন্স, তারপরে হলো সেক্সুয়াল অ্যাসল্ট। এ পারসন কমিটস সেক্সুয়াল অ্যাসল্ট if they intentionally touch another person, the touching is sexual and the person does not consent. খুব একদম সিম্পল ডেফিনেশন সেক্সুয়াল অ্যাসল্টের, যে commits and sexual assault আপনার অফেন্স যদি ইন্টেনশনালি টাচ করে আরেকজনকে এবং টাচিংটা সেক্সুয়াল টাচিং হয় এবং ওই পার্সনে যে কনসেন্ট দেয় না এই টাচিং এর জন্য, তখন এই অফেন্সটা কমিট হয়। ক্রাউন প্রসিকিউশন আপনার যেটা আপনার যে ডেফিনিশন অফ কনসেন্টটা মেইন মানে আপনার স্ট্যাটুটরি ডেফিনিশন যেটা আছে সেটা হচ্ছে if she agrees by choice and has the freedom and capacity to make that choice. ওকে, যে সে বাই চয়েসে সে এগ্রি করেছে কিনা এবং whether she had the capacity and freedom to make that choice. এগুলো খুব কমপ্লেক্স ইস্যু হয়ে দাঁড়ায় যখন কোর্টের মধ্যে যায় সেক্সুয়াল অ্যাসল্ট কেসগুলো। এগুলো অনেক অ্যানালাইসিস হয়, অনেকগুলো আপনার আর্গুমেন্ট হয় যে আসলে কনসেন্টটা দিয়েছে কিনা। Whether a complainant had the capacity, for example, আপনার age and understanding, to make a choice about whether or not to take part in the sexual activity at the time in question, whether he or she was in a position to make that choice freely and was not constrained in any way. Assuming that the complainant had both the freedom and capacity to consent, the crucial question is whether the complainant agrees to the activity by choice. তাহলে এখানে particular question হলো কি by choice এটা হয়েছে কিনা। The question of capacity to consent is particularly relevant when a complainant is intoxicated by alcohol or affected by drugs. কোনো কাউকে যদি ইনটক্সিকেট করা হয় অ্যালকোহল দিয়ে অথবা ড্রাগস দিয়ে এবং তার যদি তখন যদি তার সাথে কোনো সেক্সুয়াল মানে অ্যাক্টিভিটি করা হয় তখন এটা একটা কোয়েশ্চেন হয়ে দাঁড়ায়, এটা কোয়েশ্চেন মার্ক হয় যে তার ওই অবস্থায় ইনটক্সিকেটেড অবস্থায় এবং ড্রাগস নেওয়ার পরে whether she had the capacity to consent. এটা তখন খুব ইম্পর্টেন্ট আর্গুমেন্ট, particularly relevant আপনার পয়েন্ট ইস্যু হয়ে দাঁড়ায় যে ওই অবস্থায় তার কনসেন্টের ক্যাপাসিটি ছিল কিনা। আন্ডার দ্য এজ অফ 16 cannot consent, যদি বাচ্চার বয়স যদি 16 কম হয় তাহলে সেক্সুয়াল অ্যাক্টিভিটির জন্য সে কনসেন্ট দিতে পারে না। সো আন্ডার দ্য এজ অফ 16 you cannot give consent. Penalty for rape. Rape is indictable only and carries a maximum penalty of life imprisonment. যেগুলো মোর সিরিয়াস সেক্সুয়াল অফেন্স আপনার সেটা হচ্ছে রেপ, এবং রেপ গুলা ইনডাইক্টেবল, শুধু ক্রাউন কোর্টের মধ্যে এই রেপ অ্যালিগেশন গুলো ট্রাই হবে এবং লাইফ ইমপ্রিজনমেন্ট যদি আপনার গিলটি হয় আপ টু ম্যাক্সিমাম অফ লাইফ ইমপ্রিজনমেন্ট হইতে পারে। And penalty for sexual assault, the offense is either way with the statutory maximum penalty in the magistrate's court or 10 years imprisonment in the crown court. Otherwise, it is an either way offense carrying a maximum of 10 years imprisonment. আর sexual assault case গুলো ডিপেন্ড করে যে ছোটখাটো কোনো যদি ঘটনা হয় অনেক সময় ম্যাজিস্ট্রেটস কোর্টের মধ্যে থাকতে পারে যেখানে ম্যাজিস্ট্রেটস এর সেন্টেন্সিং ক্যাপাসিটি হইল 6 মান্থস, আর যদি সিরিয়াস সেক্সুয়াল অ্যাসল্টের এলিগেশন হয় সেটা কিন্তু ম্যাজিস্ট্রেটস এর পাওয়ারের মধ্যে থাকে না, দেন তারা এটা ক্রাউন কোর্টে পাঠাইয়া দেয়। বাট ক্রাউন কোর্টের সেক্সুয়াল অ্যাসল্টের জন্য ম্যাক্সিমাম সেন্টেন্স ক্যান বি আপ টু 10 years. So I will now pass to my colleague Barrister Lynn Townley to talk more on appeals. Yeah?
So in relation to mounting an appeal against conviction, as I've mentioned briefly, what the judge does in directing the jury in relation to finding of the facts and finding whether there's actually whether the prosecution have proved their case and whether the accused person is guilty or innocent. There's a number of issues that may afford a ground of appeal if they render the conviction unsafe in the context of the particular trial. So all accused people have got a right to elect whether or not to testify during the trial. The law was changed a few years ago, meaning that in certain circumstances the judge could ask the jury to draw an adverse inference from a particular defendant's failure to give evidence at trial. But this can only be done when it's legally permissible to do so, And it's the same in relation to a defendant's previous bad character. So, for example, if the defendant has previous convictions, that the prosecution have made an application to the judge to lead as evidence before the jury, that can only be done where it's legally permissible. So potentially, if the judge asks the jury to draw an adverse inference from the fact that someone has not given evidence in their own defence at trial, or that the judge has allowed the jury to hear about previous convictions of a defendant, and that the legal tests were not fulfilled, that may also find a ground in which someone can appeal against a resulting conviction in the Crown Court. So what effect does appealing against a conviction have? If the appeal is successful, the conviction can be quashed, meaning that it no longer stands. The court then has to decide whether it is in the interests of justice to order a retrial in the particular case. So just because a conviction is quashed, it might not necessarily be the end of the matter. Depending on why it was quashed and the circumstances of the case, the Court of Appeal can still order that there is a second trial in the case. In exceptional circumstances, there could also be a third trial, but that is rare. There are other ways in which appeals can be partially successful as well. But if the appeal is wholly successful and the Court of Appeal decides that it's not in the interests of justice to order a retrial, then the conviction does not stand, and the conviction will not be recorded then against the person who was originally convicted in the Crown Court. In relation to appealing against a sentence of the court, it's also open for any defendant who's convicted and sentenced to appeal against the conviction and the sentence both, or just to appeal against the sentence. And there's a right to appeal against the sentence even where the defendant has been advised and has pleaded guilty to the offence itself. Any resultant sentence can still be appealed. Now, on what grounds can you appeal against any sentence of the Crown Court? Well, if the sentence is deemed to be wrong in law, which is just as it said, it's a sentence that could not have been lawfully passed in the circumstances. Also, if the sentence is wrong in principle in the circumstances of the case, or if the sentence is manifestly excessive. So, in other words, the sentence is essentially too long. So if it's a term of imprisonment, it's too long in the circumstances of the case. The court, when deciding particularly on custodial sentences or on non-custodial sentences, or what the level of seriousness of the offending is for sentencing purposes, has to look at guidelines. So the judge has to be guided by nationally agreed sentencing guidelines, which have to be applied in all cases, unless it's in the interests of justice not to do so. So in the vast majority of cases, the judge has to look at the sentencing guidelines. There are very few offences that now don't have a specific sentencing guideline, but the majority of the most common offences do have a specific guideline. Those guidelines have to be discussed between the judge and both counsel before sentence is passed, and the judge has to give an explanation as to where the sentence falls within the guidelines, and to give reasons as to why the particular sentence was imposed. If the sentence is outside the guidelines with no particularly good reason, then that may give ground to an appeal against the sentence. And also, if the sentence appears to be, it has to be severe in the circumstances. So not only outside the guideline, but considerably outside the level within a particular guideline as regard to the length of sentence or the type of sentence imposed. So this allows the Court of Appeal on an appeal against sentence to actually look at the sentence afresh in relation to the grounds of appeal. If there's any remarks that the judge has made in relation to the sentence as well, which reveals that the judge may have taken irrelevant considerations into account, that would also potentially be appealable. The judge also has to follow the correct procedure when sentencing a defendant as well, and if there are any procedural errors, that may also be a ground to get the Court of Appeal to look at the sentence again. Also, if there's a sense of grievance, so for example, if there has been some kind of indication given by the judge in relation to the type of sentence imposed, and then that's been reneged on, and there was a legitimate or proper sense of expectation on the part of the defendant, well, then the Court of Appeal could interfere with that sentence as well. Similarly, disparity of sentence. So if there are a number of offenders that are charged and tried together, and their sentences are different where it wasn't actually merited on the facts of the case, that may give ground to appeal. So, for example, what the judge would need to do when sentencing was look at all their respective roles. So, for example, if a number of people were charged, for example, with drugs offences, the particular roles of each individual needs to be looked at carefully before sentence is imposed. And if the roles are very different, for example, some people were involved in low-level dealing and others were higher up the chain in relation to the drug dealing, then one would expect the sentences to be different for those with greater, more central roles than those who were at the end of the supply chain. And if that's not reflected in the judge's sentence when it has come out in evidence at the trial, then that may afford a ground of appeal. And equally, where the judge has just sentenced a broad sentence, similar sentences for all the offenders, without making any distinguishment between the individual roles. So, for example, there was a number of offenders, each with very different roles and different levels of culpability and degrees of offending, and they each received similar or the same sentences. That would be a ground of appeal as well. But any differentiations in the sentence have got to be, as the case law suggests, serious rather than minor. There are some other findings that in relation to verdicts that there's also appeals against. If there's been a verdict of not guilty by reason of insanity, if there's been a finding of unfitness to plead, and where there's been a substitution of a finding of insanity or unfitness to plead, then those are also grounds that can be appealed against, but would require you to take legal advice. And finally, there's also a way in which the prosecution can ask the Attorney General to refer an unduly lenient sentence, so a sentence that was too low, back to the Court of Appeal. So, for example, if there's a genuine grievance about a sentence being too low, and this would be something that there may be grounds to complain about, or if you're aggrieved, for example, if you were the victim of crime, or if one of your relatives were the victim of crime, and it appeared that there was appeared to be a very low or disappointing sentence imposed in particular circumstances, the prosecuting authorities can refer the matter to the Attorney General's Department, who can then refer the matter to the Court of Appeal to consider the sentence, and the sentence the higher sentence can then be imposed, and the sentence can be increased by the Court of Appeal. In relation to these types of cases, they don't apply generally to cases that are heard in the Magistrates' Court. It's generally only cases that are heard in the Crown Court, usually indictable only matters, so matters that can only be heard in the Crown Court. But there's also some matters that are specified that are either way matters, so matters that could be heard in the Magistrates' Court or the Crown Court that have been specified as being referable by statute, that are either way matters, but the attorney can still refer them to the Court of Appeal. And these include things like sexual assault, and then a number of other sexual offences involving children. If the sentence is deemed to be too low, and you're aggrieved, it may well be that if you are a victim in the case, or a family of a victim, that you could write to the CPS or speak to the prosecutor to indicate that you feel that the sentence is unduly lenient, and then it will be for the local prosecuting authority to make a decision as to whether they feel the sentence meets the test of being unduly lenient. So unfortunately, it's not enough that you just feel that the sentence isn't severe enough. It has to be unduly lenient, which means that the Court of Appeal would be likely really to interfere and increase the sentence. Then it's a matter for the prosecuting authority as to whether they will refer the matter to the Attorney General, who then has got power to refer the case back to the Court of Appeal. And then the Court of Appeal can consider whether they feel the sentence to be unduly lenient. If they don't, then in a way nothing is lost, because the sentence is not interfered with, so the sentence of the Crown Court still stands as before. But if the court take the view that the sentence is unduly lenient, and that they also feel that the sentence needs to be interfered with, so in other words increased, then the Court of Appeal can increase the sentence. In relation to what the Court of Appeal are likely to do in relation to the increase, they have to take account of what is called double jeopardy. So the fact that the defendant has already been sentenced in the Crown Court, they have to make a reduction in what would have been the overall sentence to allow for the fact that the defendant is being sentenced for a second time. So the sentence would be lower than possibly was hoped for, but it can still afford an overall increase, meaning where the defendant is serving a custodial sentence, the custodial sentence that they have to serve will be longer. So as regards references by the attorney, these require leave as well. And also, if you wish to appeal against sentence on conviction, or just conviction, they also require the leave of the court. And as I mentioned at the start of the programme, they require quite swift action, because there are time limits of 28 days to get the notices of appeal sent to the Crown Court. Thereafter, the Crown Court will send the appeal notices and the grounds of appeal to the Court of Appeal. Then the way that the Court of Appeal deals with the sentences is they will an appeal against sentence or conviction is the Court of Appeal will make a decision as to whether it will grant the person who's appealing leave to appeal. If leave to appeal against the conviction and or the sentence is granted, then generally, if you're publicly funded, there will be a representation order made in respect to hearing the appeal. So, in other words, the appeal and your representation at the appeal will be covered by legal aid. If, however, the Court of Appeal refuses, and it's a sift on paper, it's not a full hearing before the court. If the Court of Appeal were to refuse leave to appeal in respect of a conviction or sentence, that's not necessarily the end of the matter. You can also renew your appeal either on the papers or before the live court. But in those circumstances, the advocate is not entitled to the benefit of having a representation order, which means that your advocate would have to act pro bono, because they would not be paid for their time. So that would be something that you would need to discuss with your solicitor or barrister. So essentially that covers the whole topic of appeals. It is complex, and you need to get your legal representatives, if you have them, to act fairly quickly following a conviction to ensure that the Court of Appeal have jurisdiction to hear the appeal.
থ্যাংক ইউ লিন। দর্শক, আপনারা শুনছেন ব্যারিস্টার লিন টাউনলি। সে দীর্ঘ প্রায় 25 বছরের অভিজ্ঞতা সম্পন্ন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার। সে আপনার ক্রাউন প্রসিকিউশন সার্ভিসের ফরমারলি অ্যাডভোকেসি ম্যানেজার হিসাবে কাজ করেছিলেন, এবং আপনার লন্ডন ইউনিভার্সিটিতে এখন আপনার যারা বার ব্যারিস্টারি পড়াশোনা করে তাদেরকে বিপিটিসি কোর্স বলা হয়, তাদেরকে পড়াশোনা করায়। আজ আমাদের সময় শেষ হয়ে গেছে দর্শক। আজকের প্রোগ্রামটি আবার পুনঃপ্রচার করা হবে নেক্সট স্যাটারডে দুপুর 1:30 থেকে 3টা। তাছাড়া আজম কো সলিসিটরসের ফেসবুক এবং ইউটিউব চ্যানেলেও প্রোগ্রামটি আপলোড করা হবে। সবাই ভালো থাকুন, সুস্থ থাকুন, এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।